Hello everyone, this is Tom Fox. I'd like to welcome you to episode 168 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions. Today I have Dan Cogdell. Dan is one of the top criminal defense attorneys in Houston. He's had a wide range of cases over his career, from the Waco David Koresh defendants through Enron, through Alan Sanford. He's got a lot of experience in white-collar crime. Dan talks to us today about some of the unique issues around defending individuals in FCPA cases with the internal investigations outsourced in many instances to outside law firms, what an individual can do to protect himself, what an individual can do to assure that he has funds for an adequate defense, and walks us through the criminal procedure process. The episode comes in at just over 28 minutes. I hope you enjoy it. Thank you for listening. Criminal defense lawyers, Dan Cogdell. Dan continues the Houston tradition of top-notch, high-profile criminal defense attorneys. We have a long tradition of that in Houston, and I'm proud to say that you've continued that tradition in fine form. So, Dan, with that introduction, I really appreciate you taking the time to visit with me this morning.
My pleasure, Tom. Always a pleasure to talk to you. Thank you.
Dan, the reason I wanted to visit with you and have you talk to the folks who listen to my podcast is that there has been an increasing call and increasing information from the Department of Justice that they're going to go after individuals criminally in the FCPA context. And most of the folks who I work with are corporate legal types or corporate compliance types. They may have come out of private practice, but they almost were always on the civil side of things, and they really don't have any idea about criminal side of law, criminal defense, criminal procedure, criminal rights of accused, and those sorts of things. So I thought it would be a good opportunity to visit with you and have you walk us through some of those topics and maybe explain some of the basics that people need to think about if they get caught up in an FCPA investigation. So with that, if someone came to you and said, my company is under scrutiny and I've been asked to give a statement or meet with outside counsel who's doing an investigation, what could you counsel them?
Well, good question, but, rule number one, I would never want a client or a potential client, Tom, whether it was a corporate client or an individual client, to meet with anybody from the Department of Justice, frankly, in any case, but certainly in an FCPA case without competent counsel. The first thing they need to do is hire a lawyer that's been there and done that, not only handled investigations, but in all, for the greater good, have somebody that's actually tried in a courtroom the sort of case that's being investigated. So rule number one is find competent counsel. No ifs, ands, or about that ever, and so we go from there.
Dan, one of the anomalies in the FCPA world is, although obviously the Department of Justice enforces a criminal law, in many instances they have not done the initial investigation. They may review an investigation, but it's almost always done by outside counsel. Would that same rule hold true, or would your same advice be consistent for a company that has retained an outside law firm, a private law firm, to do their investigation?
Yes, but here's the rub, Tom, and I've seen it time and time again, not only in FCPA cases, but in any sort of situation where there's been an internal investigation. What the corporation's interests is almost inevitably different than the employee's best interest. The corporation, of course, is looking for the greater good. That means the survival of the corporation or the corporation itself being avoiding criminal charges. Employees, unfortunately, are almost inevitably viewed as replaceable, if not disposable. So what many times happens is, with an outside law firm coming in to do the corporate investigation, the individual, the employee at the corporation, of course, thinks they're talking to, quote, their lawyer, close quote, when it's not that way at all. The lawyer's representing the corporation, and an individual feels like outside counsel are covered by the attorney-client privilege, and they're not most of the times, and frequently that the employee gets served up on a platter. I mean, you pointed out to me that the recent Shell Oil versus Ritt case from the Texas Supreme Court, which of course held that the information provided by corporations to the Department of Justice about a potential FCPA violation is absolutely privileged, and an employee, had no rights and from defamation or libel from that. And that's just a sort of a confirmation of my concerns I've seen over the years.
Dan, you bring up some very interesting criminal procedural issues, or at least procedural issues, and something that I've been thinking about and worrying about for a long time, and one of which is the notice that a outside counsel who's performing an internal investigation is required to give an employee, and that's in the corporate context called the Upjohn warning.
Right.
But my concern is that may not go far enough to inform an employee of his rights if he gets involved in a criminal investigation later. Any thoughts on that?
No, you're absolutely right, and I've seen it time and time again where, I say time and time again, I bet you I've been in, probably, Tom, a half a dozen trials where I have who's now sitting next to me in a federal courtroom somewhere and having to cross-examine the firm's lawyer, the corporation's lawyer, about statements that my client made to that corporate lawyer, and inevitably when my client finds out that I've got to cross-examine, quote, their lawyer, close quote, they turn white no matter what complexion they are, and it's a very challenging situation, and it's very unfair most of the time, because the employee, again, didn't realize the statements that they were making would be, literally used against them in a criminal courtroom. They never imagined that scenario, and it happens fairly frequently.
Dan, let me turn to another subject which comes up from time to time, and that is who should pay for an individual employee's defense counsel. Some corporations have made it clear that for their own internal employee relations, they will pay for an employee's defense anytime, anywhere, and they will guarantee that employee receive the funding for his criminal defense lawyer. Other corporations, unfortunately, don't take such a view. But how would you counsel an employee to ask that question or seek that sort of commitment from his employer if he's still employed during an investigation?
Well, they need to find that out as early as they can, and I would advise a potential client to sit down and meet with his supervisor or meet with the corporate team and explain to them the loyalty that they've had, the employees that have had to the corporation, and the work that they've done and the years that they've put in, and it's the right thing to do for the corporation to back them up, and they want to do the right thing by the corporation, and the corporation should want to do the right thing by them. All those niceties having been said, it's of course a corporate decision. It's a case-by-case basis. I've seen it both ways, Tom, where a corporation is hired, and generally I'm a small shop lawyer, as you know, and I typically don't get hired on the investigation side of things, or the internal investigation side of things. Typically I don't get involved until charges have been filed. But all that having been said, I've seen it both ways, and more and more it seems like corporations are more willing to fund for the defense of their employees than they have in the past. But the only leverage an employee typically has is goodwill and equity.
One of the things that is typically available to senior management and the board of directors is directors and officers liability insurance. One of the side benefits from that in the FCPA world is that it is allowed in certain individuals who've been charged criminally to hire very competent counsel and be sort of the cutting edge of the legal debate in the courts about the FCPA. And it's really allowed a class of lawyers such as yourself to be available to people to defend them going forward. Kind of with that, Dan, I'd like to turn to, though, many of the listeners to this podcast don't understand or don't know how the criminal process might work. So could you just walk us through that from your experience in federal court?
Sure. And to jump back a second, Tom, on the D&O the director and officers insurance, while that has been a great source of funds for lawyers, a lot of those policies will pay for the counsel only up until there has been a determination that, or until there has been a determination that criminal conduct has occurred. And oftentimes, while the lawyers will be funded out of a D&O policy during the investigatory portion of it, there's lawsuits that are almost inevitably filed between the carrier and the insured as to whether or not there was criminal conduct, and you have kind of a mini trial oftentimes where a judge may determine that criminal conduct occurred from a civil standpoint, from a preponderance standpoint, which of course is a wholly different burden of proof than the criminal stuff, and the funding gets turned off, or the resources for the legal fees gets turned off fairly early on in the process. That happened to all of us here in Houston in the Stanford case. While we were funded up to a point, once the federal judge made her determination that criminal conduct had occurred, then the funding stopped. So with that having been said, from an overview of a criminal process, and I don't know how long-winded you want me to be, but of course the first thing is the investigation, which we've talked about. Once a prosecutor makes a determination or a decision to present the matter to the grand jury, the grand jury process can take weeks, can take months, can take years. A grand jury, as most of your listeners know, the constitutional or historical purpose of a grand jury is to determine whether or not there is probable cause to believe that an individual, or perhaps in this case a corporation, has engaged in criminal conduct. A grand jury is a very pro-prosecution, lopsided, one-sided investigatory tool. As a citizen, you do not have the right to even know that there's a grand jury investigation of which you are the target. You don't have the right to know who the grand jurors are. You do not have the right to be present when witnesses are called. You do not have the right, even if you are called, to have your lawyer in the grand jury room. You don't have a right to know, as I mentioned, who the witnesses are. You can't cross-examine the witnesses. At the end of the day, a grand jury is going to do what a prosecutor asks it to do. The talismanic phrase in my world is, a grand jury would indict a cheeseburger if a prosecutor told it to. And unfortunately, that's largely true. A grand jury is going to do exactly what a prosecutor wants it to do, because the grand jury, no matter how well intended, they only hear what the prosecutor wants to tell them. So in the federal system, Tom, the grand jury investigations are usually fairly detailed and fairly lengthy. A good prosecutor, a federal prosecutor, and certainly the FCPA types, they're going to use it not only as an investigatory tool, but they're going to use it to nail down the testimony of many of their witnesses and have them testify under oath, so they've got that testimony in a sack, and the witness can't backtrack or verify or vary rather from that. So the investigations of these things can have a very long tail on them. Like I mentioned, it can take a couple of years, just depending. Once the grand jury has returned an indictment or a true bill, then the fun really starts, and the discovery process begins in the federal system, which is, again, it's fairly specific in terms of what prosecutor you're dealing with and what judge you're dealing with. It varies greatly from jurisdiction to jurisdiction, from district to district, and from prosecutor to prosecutor. Some prosecutors will give you pretty much free and open discovery. Some of them will fight you tooth and nail. Again, it's fairly case specific. The negotiations to resolve the case or to position the case for trial, of course, are ongoing. Most of my clients that hire me, Tom, they want to try their case because they feel like they're not guilty, and that's why they're in my office. That having been said, of course, a lot of my cases get resolved without a trial, just like everybody else's. But generally speaking, and again, this is a huge oversimplification of the process, it's about a year to 2 years once a client has been charged in a white-collar or complex FCPA case, between about a year and 2 years between the time the case is charged and the case is resolved. If the case is tried and won, great. It's the end of the favorable outcome that everybody wants. If the case is lost, or even if there's a plea of guilty, then there's a pre-sentence report investigation that occurs, which can take months in and of itself, where losses are determined and aggravating roles are determined and all the factors are positioned in front of the judge as to what the appropriate sentencing guidelines are in that specific case. As most of your listeners probably know, the sentencing guidelines used to be mandatory. It's been probably 8-9 years now where the Supreme Court overturned the mandatory aspect of the guidelines and made them advisory, so the judges have a little bit more flexibility in the sentences that they can impose, although most judges are still more or less sort of guidelines-based judges. Now, that's a long-winded, windy, hyperbole-filled example, so pepper me with some specific questions, and maybe I can be a little bit more literate for you.
One of the things that most civil side practitioners don't understand is the pre-trial procedure that occurs in a criminal case. And frankly, there's a lot of work that you would do to not only prepare for trial, but really to educate the judge on the law and the facts. Could you maybe walk through some of the hearings that you would have on the pre-trial part of your docket?
Sure. They're probably less intensive and less common than civil practitioners are used to, because, believe it or not, your discovery rights as a defendant in a federal case are far less than your discovery rights as a civil litigant, and that's just the way the beast is built. So while you'll have discovery motions, of course, you'll have Brady or Giglio motions, which are requiring the government to turn over whatever information they have that is favorable to the defense. You may have some motions to quash or motions to dismiss based upon the failings that you see in the government's indictment. You could have a motion for a bill of particulars, which is quite common, where the lawyers need to find out more about exactly what the theory of the prosecution is in terms of the who, the what, the where, the when, and the why. Some indictments are very general and very vague. Some are very, very specific. But obviously, information is power in any game, and certainly it is in the criminal context, and it's not uncommon at all for a lawyer to file a motion for a bill of particulars to educate himself on exactly what theories the government is relying upon or what witnesses. You also, of course, need to find out the identity of the witnesses. That is a fairly flexible standard, believe it or not, and I have been in situations where I don't know who the witnesses are that are going to be called, and it's maddening and frustrating, but it's and here's what I always like to explain to potential clients, and you can see the fabric on the chair that they're sitting in pucker up when I educate them or when I give them this example. Oftentimes, civil cases and even investigations, Tom, they're like a ballet. They're very disciplined. They're years in the making. They're very sophisticated, and they're just a beautiful thing to watch, because so much energy and planning and strategy has gone into them that it's a great thing to watch if you're a fan of ballet, which parenthetically I'm not. A criminal trial, even a federal criminal trial, it's a bar fight. I mean, things happen so quickly that unless you know where the pool cue is, you're going to get hurt. Unless you know where the sawed-off shotgun is that the bartender may or may not keep, you might get killed. You better know where what your exit strategy is and whether the back door is locked or unlocked. My point being, criminal trials, be it state or federal, are smart you are and how sophisticated you are and how much planning you've done in other situations. You're living on the wet end of the spear, and oftentimes it is trial by ambush. Many times it is trial by ambush, and those are skills that can't be acquired during trial. You better have years of experience before you get there. So that's kind of my childish example, but unfortunately I believe it to be an accurate one.
Well, and I'm glad that I don't have to play in that pond because I certainly don't have those skills. Dan, let me change the subject to the really something else. And actually, I should, before I change the subject too much, is there really, I guess the thought I've heard you say the most consistently is get in to a lawyer as quickly as you can, get counsel as quickly as you can, cooperate to the extent that your lawyer thinks is appropriate, but certainly work with someone like yourself to help protect all of your rights, both in a what may appear to be a civil side investigation, but could lead to a criminal side investigation and or indictment.
No, that's absolutely true. And the other thing that I want to throw out there while I'm thinking about it, Tom, is people really fail to understand how unfair the criminal justice system can be. They have the notion when they come in here that, well, I'm presumed innocent, and the government has to prove these things beyond any reasonable doubt, and the judge is going to be there to protect every right that I have, and it's an unfair fight from my perspective, and I'm way ahead of the game because I have all these rights, and the government has none of these rights, and I'm well protected by the system itself. I wish I could say that was true. I mean, when I stood up in front of the first Enron case that was tried here a decade or so ago, the presumption of innocence really wasn't filling the room, right? The burden of proof was not on the government. It was on me. Presumption of innocence was about as believable and credible in a case like that as was the tooth fairy. The other thing is, and it really took me a long time. I've been doing this, as you know, for 33 years, which is frightening for me to say. But I didn't, when I was, even as a young lawyer, I didn't realize the rewards that some prosecutors receive from from being a prosecutor. And again, I'm not throwing anybody under the bus because most of these people are people that I respect. But just using the Enron case as an example, one of the prosecutors in the Enron case was a lady named Kathy Rumler. I got along with Kathy. I thought she did a good job. I actually liked her. I never caught her lying, cheating, or stealing to me. But she went on to become White House counsel to this fellow named Barack Obama. You can move very quickly up the ranks. Sean Berkowitz, another lawyer that I dealt with in the Enron case, he's now a partner at Latham Watkins. I have all the respect in the world for Sean, but in a very short period of time, these young lawyers with the DOJ, and I'm not saying they're not qualified. I'm not saying they lied, cheated, or stole. They didn't. I like them. They were good people. But the point is, you can move from a job where you're making $120,000 a year up, and 4 or 5 years later, you're making $1 million, you're making $1.5 million, you're making $2 million, or a few years later, you're White House counsel to the president. So the point of that is, a lot of these young prosecutors are very, very, very highly motivated and incentivized to get involved in some of these cases because the rewards can be great. Again, no spears thrown at their character or their ethics. But when you get into the federal realm, sometimes the effort at conviction or the effort generally can be supercharged because the long-term or even short-term rewards for a prosecutor can be really, really significant.
No, we've certainly seen that in the FCPA world. There's a fair amount of times when prosecutors have gone on to pretty prestigious positions, either in public service or indeed in private practice. So certainly well to be considered as going forward. Dan, if I could, I'd like to now change to something I've really enjoyed watching you do over the years, and that's your racing team. And I say that because in addition to being one of the city's top criminal defense lawyers, you carry on the tradition of being, if not eccentric, certainly high profile in other areas, and that's your racing team. I always thought it was just a Cogdell racing team, but could you give us a few words about that?
Yeah, I'm the world's oldest teenager. You can look it up. Just Google world's oldest teenager, and my face will pop up somewhere. I've been racing motorcycles, Tom, since I was riding and racing since I was 13 or 14 years old. Ever since my junior high football coach explained to me in no uncertain terms that I need to find another sport, so I did. And I'm pushing 60, but I still race motorcycles every year or so. I'll still do the Baja 1000, which is the longest point-to-point off-road motorcycle race in North America. You start in Ensenada, Mexico, and on the longer or on the point-to-point routes, you'll end up in La Paz, which is just north of Cabo. And it's something that I don't know how to explain it other than to say I'm not any good at anything else. I don't hunt, I don't fish, I play golf, but just abysmally poor. And motorcycle racing, parenthetically, is how I first came to meet my mentor and my hero, Racehorse Haynes. When I was back in high school, Mr. Haynes was racing motorcycles, and when you and I were at the University of Texas, he won this little case called Cullen Davis, and in my first interview with Richard, I brought up the motorcycle racing thing, and I can assure you, Tom, that helped me get that job back in the day. But like I say, it's very cathartic for me. When you're racing a motorcycle, you don't have much time to worry about or think about the motion that you should have filed, or the client call that you should have returned, or the esoteric position you're taking in the pleading. You're kind of worrying about not getting run over, or hitting a cactus doing 80, or hitting a tree doing 40. You're just trying to get through, and I always explain it as a good drunk without a hangover. You just it flushes everything out of your cerebral cortex for a period of time, and it's cathartic. It's actually relaxing for me. I'm so upside down that racing motorcycles is a form of relaxation for me.
I was going to say that's exactly what it sounds like. As counterintuitive as that may seem, that it is relaxing for you.
Nope, it's and I've met a lot of my heroes through it. There's a guy named Roger DeCoster who's a 5-time world champion, and back in the 9th grade, I had Roger's poster on the wall and Raquel Welch's poster from 1001 BC or whatever that was. I've never met Raquel, but Roger's a good friend of mine to this day, and it's been a great experience, and I met a lot of really good people. And you never see any prosecutors out there. That's one of the best things about it. You'll never see a prosecutor off-road motorcycle race. Maybe one. Jay Heilman's a local guy here who his son races. But save and except Jay, I've never seen a prosecutor out at a motorcycle race.
Well, Dan, this has been way too much fun, and I've learned a ton. But unfortunately, we're nearly at the end of our time. But I was wondering if anyone wanted to follow up with you directly on any of the things you've talked about, or may even need your help. How would they get in touch with you?
Well, just Google my name, Dan Cogdell, Cogdell, and it'll have a link to my website. The website is www.cogdell-law.com, and our office number is 713-426-2244. But I'm easy to find, Tom, save and except motorcycle racing and my beautiful wife and paying for my kids' tuition at TCU. I don't have much of a life, so I'm always around. But I appreciate 100% the opportunity to talk to you and your listeners, and if I can ever be of any help in any shape, form, or fashion to you, please let me know.
All right, Dan. Well, thanks a lot, and look forward to continuing the conversation.
Thanks, Tom. Bye-bye.
This is Tom Fox again. I hope you've enjoyed this episode of the FCPA Compliance and Ethics Report. If I could ask you to rate this podcast on iTunes, I would greatly appreciate it. And please don't forget to send me any questions you might have for my upcoming mailbag episode. Thank you very much.